Hi, Cairo Ozga here again. Welcome back to the weekly wrap-up brought to you by Tech Law Decoded. Thank you for the positive response to last week's kickoff episode. In this week's report on antitrust developments in tech, I cover Germany's ongoing legal battles with Facebook, Brazil's interest in the social media company's plans with digital payments, reports of a possible forthcoming antitrust investigation of Apple in the US, updates on merger reviews of Amazon Deliveroo and Google Fitbit, and finally, what this week's testimony about politics in the DOJ might mean for big tech investigations. Just a reminder, this is not legal advice, and the views expressed are my own. So let's dive right in, beginning with Germany and Facebook. So as background, in early 2019, the German Competition Authority had issued a decision finding that Facebook violated the competition laws against abusive dominance by engaging in what's called exploitative abuse by not providing users the ability to use Facebook without agreeing to wide collection and combination of their data, both on and off the social media platform. So that included data collected when users visited third-party websites that had a Facebook like button at the bottom. The decision was considered novel and controversial, in part because it was based on a violation or an alleged violation of Europe's data protection rules, the GDPR, which was a basis for the antitrust violation. The decision imposed significant remedies on Facebook, requiring it to obtain voluntary consent from users for the collection of their data. Late last year, a court hearing an appeal of that decision suspended the order from the Competition Authority and signaled skepticism about the government's theory of the case. That suspension was appealed, and this week a higher court overturned it. The court signaled disagreement with the antitrust theory of the case based on a violation of data protection rules, and instead it said that it believed there was an abuse of dominance from a restriction of the freedom of choice of Facebook users. Essentially, the court found that the all or nothing option that users were given, meaning either allowing for the creation of so-called super profiles or having no access to Facebook at all, infringed on a consumer's decision-making sovereignty. This is a concept probably less familiar to people outside of the European jurisdictions, but an interesting one nonetheless. The focus now goes back to the original reviewing court, which is still to make a ruling on the merits of the appeal. And in the meantime, Facebook must comply with the Competition Authority's decision and order, which would require it to set up a new data policy, unless, of course, a decision on the appeal was heard before the deadline. So, a lot more to follow here. The case could have a major impact on how broadly antitrust is stretched in the tech space. And that could be either as direct legal precedent or as inspiration for policy changes, something we might be already seeing in Europe with the proposed new competition tool. In other Facebook news, Brazil's government has suspended the social media company's launch of a digital payments feature on its WhatsApp messaging service. Facebook was beta testing the feature in Brazil, and within days of the announcement, the country's central bank and its competition authority suspended the rollout while investigations could be conducted. CADE, the competition authority, will examine a partnership between Facebook and a card operator that is to process the payments on WhatsApp. And in particular, it will focus on whether that arrangement includes any exclusivity that might lock out Facebook's competitors. In Apple news, reports this week that the DOJ and an undisclosed set of state attorneys general are opening investigations into Apple over its terms of use with app developers on the App Store and Apple Pay. Like the EU investigation that was announced last week by the European Commission, the US appears especially interested on the 30% commission that's charged by Apple. If the reports pan out, Apple will essentially face parallel antitrust investigations for similar conduct on both sides of the Atlantic. And it would seem to face a level of antitrust scrutiny that it has not yet had to endure. In tech deal news, the Amazon Deliveroo saga had another interesting twist this week. After a full throttle phase 2 review, UK's competition authority had provisionally cleared the deal due to the financial deterioration of Deliveroo as a result of the pandemic. The authority had received public comments about that decision, including about potential negative competitive effects from the transaction, as well as criticism of the agency's reliance on the so-called financial condition defense. Following those comments, the CMA has now released a revised decision, still granting provisional clearance of Amazon's investment in Deliveroo. However, the decision backtracks on the financial condition as a basis for the clearance and provides instead a detailed competitive analysis that concludes that there's ample competition in the relevant markets for online restaurant platforms and online convenience groceries. EC's phase 1 review of Google's proposed acquisition of Fitbit is ongoing. Reports this week indicate that third parties have received initial RFIs. These questionnaires concern what sort of health data is collected by Fitbit and what usefulness it might have for Google and its various services. The focus of the EC's investigation appears to be as much on the accumulation of data that might result from the acquisition of Fitbit as the ACCC's investigation of the same deal. The ACCC being Australia's competition authority, which last week, as we reported, made known some preliminary concerns about the Google Fitbit deal. Finally, a hearing before a U.S. House of Representatives committee this week heard testimony from a DOJ official about a pattern of political influence from the attorneys general on where to focus agency resources on its investigations. The testimony involved cannabis and fuel emissions, so you might wonder, what does that have to do with tech? And the answer is that a politicized antitrust division combined with reports lately of heavy lobbying by big tech firms in DC would suggest a uncertain and difficult to predict regulatory climate in the US right now for big tech. And it might also suggest that we are in for a roller coaster ride in the DOJ's ongoing big tech investigations, and including the one of Google, which reports have indicated appears close to resulting in charges being brought. That's it for this week. For more on the latest developments in the worldwide efforts to regulate the digital revolution, check out techlawdecoded.com or follow me on Twitter @KaiRozga. Thanks for joining and see you next week. Have a great weekend.